Hi, my name is Elisa Chiu. This video is dedicated to my Equity and Trust 1 assignment. Before I begin, let's take a look at the questions. The focus of this question is twofold. The first part requires a discussion on the effect of the Judicature Act 1873. On the second part, the question calls for critical assessment on how far common law and equity could be said to have views. Let's dive into the first part of the discussion. The Judicature Act 1873 was passed as a result of long-standing conflict between common law and equity. It is essential to understand the situations before the Act was passed in order to appreciate the effect of the Judicature Act by comparing the changes it has made pre and post its enactment. Prior to the 1870s, the judicial system in England was divided between the common law courts and the courts of equity. The two courts were separated because there was a distinction in terms of the administration and the substantive laws. The procedures in administrating them were different. The common law courts were divided into the King's Bench, the Court of Common Pleas, and the Court of Exchequer, whereas equity was administered in the Chancery Court. All actions in the common law courts had to be commenced by a writ. This was done in Latin or French, and if the action did not fall into the prescribed writ, a claimant could not enforce his rights. Equity, on the other hand, was not bound by the writ system, and cases were heard in English instead of Latin. The consequences of having separate courts would be that a claimant faced the difficulty of having to elect a court to enforce his rights. The other reason for having separate courts was because common law and equity had developed their own set of rules which were quite distinct from each other. Equity had developed new principles such as the trust, equitable remedies such as specific performance, restitution, injunctions and rescission, and fiduciary laws. As a result of new rules being created, conflicts may arise such that both courts reach different conclusions in the same matter. Take trust, for example. Common law only recognizes a person's right to enforce his interest in the land if he owns a legal title. So consider the situation where a wife has contributed extensively towards the purchase price of a property, but her husband is the title owner. Under common law, the wife would not have any interest in the property despite her contribution because legally, she is not the property owner. However, under equity, a beneficial interest may arise in her favor by establishing a resulting trust. From this example, we could see how both the courts could reach different binding decisions in regard to the same matter. To prevent this, the chancellors began to issue common injunctions to stop the enforcement of a common law order or judgment. The validity of common injunction was later tested in the Earl of Oxford case, where it laid down the modern foundation that if the rules of common law and equity are in conflict, equity is to prevail. Despite this decision, the core problems still remained. Therefore, the Judicature Act 1873 was enacted to resolve this issue by fusing common law and equity. The first change that was brought about by the Judicature Act is the abolishment of separate common law courts and courts of equity. It created a single Supreme Court of Judicature, administrating both common law and equity. So now, a claimant does not have to shuttle in between common law courts and Chancery Court to seek a suitable enforcement of his rights. Both common law and equity can now be administered in the High Court. And if the party is unsatisfied with the decisions of the court, he could appeal to the Court of Appeal and thereafter to the Supreme Court. Furthermore, Section 24 of the Judicature Act gives judges the power to administer both legal and equitable rights, claims, defenses, and remedies. Most importantly, common injunctions are now abolished, and all cases are now heard in English. All these changes are clear evidence that the Judicature Act have fused the administration of the common law court and the Chancery Court. But what about the substantive aspect? Has the Judicature Act fused the common law and equity together? Under Section 5 of the Judicature Act, it is clearly stated that in terms of conflict between the rules of equity and common law, equity is to prevail. This seems to suggest that the substantive laws may have fused, because if equity is to prevail in all circumstances, there will only be a decision reached by a single court. However, this is not necessarily the case. There are still instances where a single court could reach different decisions in the same matter. The subject on the fusion of substantive law has therefore governed three different views: the anti-fusion view, the pro-fusion view, and the intermediate view. This leads to the second part of the discussion of how far has common law and equity fused after the passing of the Judicature Act 1873. According to the anti-fusion school of thought, the Judicature Act 1873 fused the administration of the courts, but did not fuse the substantive law. This is the general view adopted by the judiciary in Australia. There are multiple English case laws which also support this anti-fusion view. The crux of the anti-fusion argument is that there exists a continued distinction between common law and equity in terms of remedy. Therefore, fusion is impossible. There are mainly three arguments put forward by the anti-fusionists with respect to the distinction in remedies. First is that common law wrongs and equitable wrongs remain two different types of wrongs. A wrong is basically a breach of duty, which triggers compensation for the lost cost. The anti-fusionists argue that common law damages should not be awarded for a purely equitable wrong. Examples of equitable wrongs are breach of fiduciary duty and breach of confidence. The appropriate remedies for such wrongs were an injunction and an account of profits protected in equity. Therefore, in Matter Unrostov AG and Donaldson, Lufkin and Jenrette Incorporation, Lord Justice Slade was clearly of the view that damages at common law were not recoverable for a breach of trust. However, there are some authorities which came in opposing view. For example, in Seeger and Copydex, the Court of Appeal awarded damages despite the purely equitable nature of the claimant's cause of action. Situations like this, where damages were granted for breach of fiduciary duty, had never occurred before the Judicature Act. Therefore, this suggests that fusion may be possible. If damages is available for purely equitable wrong, another argument put forward by the anti-fusionists is that common law damages and equitable compensation are distinct remedies, since different requirements are applied for either of them to be awarded. Hence, they could not be fused. This view was expressed by Lord Brown Wilkinson in Target Holdings Limited and Reference, where his lordship stated that common law rules of remoteness of damage and causation do not apply to a breach of trust. On the other hand, Lord Justice Millett in Bristol and West Building Society and Mod 2 considered that the same test of remoteness of damage may be applied in equity as at law in case of a breach of trust. It is submitted that the second view should be supported, since the law in regards to damages in common law is much more developed, given that it has been progressively refined by way of being examined in numerous wide-ranging cases. Therefore, the application of restrictions should be identical. Again, this gives rise to the possibility of fusion between common law and equity. The last ground for those who insist on the separation between common law and equity is to argue that equitable remedies are discretionary, while common law remedies are as of right. Andrew Burrows, in his article, argues that this view is highly misleading. There are instances where the common law also exercises discretion. For example, in its decisions in tort, in deciding whether a defendant owes a duty of care, and in contract, when quantifying compensation. Similarly, in equity, a judge exercises discretion in deciding whether a defendant owes fiduciary duties, or in contract, whether specific performance should be granted. Both these instances show that equity and common law now commonly adopt these discretionary practices. Therefore, fusion is possible. It also facilitates the aim of treating like cases alike. To summarize, all of these arguments only lead to one point. The distinction in terms of remedies could not afford convincing ground for the suggestion that common law and equity are separated in substance. This leads to the fusion school of thought, where it is argued that the Judicature Act has fused the substantive law of common law and equity, and not just the administrations. In fact, this idea of fusion is not new and had been propounded by Mansfield and restated by Blackstone as early as in the 18th century. In New Zealand, the judiciary generally prefers this view. Likewise, in the United Kingdom, Lord Denning has expressed his view that the streams of common law and equity have flown together since the passing of the Judicature Act 1873. But what exactly is fusion? It has never been judicially explained what is truly meant by the word fusion. Maitland's lecture on equity seems to suggest that fusion takes place when lawyers will cease to inquire whether a given rule is a rule of equity or a rule of common law. According to the suggested test, there is obviously no complete fusion yet. This is evident, as it can be seen in any particular case, there is still specific reference to the distinction between law and equity. For example, the law of trust. It is very hard to describe the trust without referring to the split between legal and equitable title. Therefore, as one looks at fusion, the more practical point of view is that equity and common law should fuse. This is because fusion would facilitate the system by treating like cases alike, thereby ensuring coherence in the law. There are certain areas in laws in which the pro-fusionists suggest that fusion is needed. The first area where fusion is desperately needed is on the subject of monetary remedy for both common law and equitable wrongs. The argument is that the assessment of monetary remedy under common law and equity should be the same, where compensation is the common remedy to the claimant. There are two notable examples. First is compensatory claim for a breach of duty of care, whether under common law or equity, and a claim for damages for negligent misstatement under common law or equity. As set out earlier in this video, the assessment of compensation for a breach of duty of care under common law is limited by the concept of causation and remoteness. But when it comes to a breach of equitable duty of care, the assessment of compensation is limited by a broad but-for causation test. If common law and equity are imposing duties of care for the same reason to protect the vulnerable, there seems to be no reason why different set of rules should apply for the assessment of compensation. Therefore, the suggestion is that the common law and equitable tax can be dropped, and the defendant would simply be subject to a legal duty of care, where the quantifications of the remedy is the same in all cases. The same difficulty arises in the case of negligent misstatement. A claimant could either claim for damages under common law or in equity by virtue of Section 2, Sub 1 of the Misrepresentation Act 1967. However, the assessment of damages varied. Under common law, a claimant who suffered loss as a result of negligent misstatement by the defendant could only claim damages for losses that are reasonably foreseeable. Under the Misrepresentation Act, however, a claimant could claim for all losses flowing directly from the negligent misstatement. Given the different set of rules involved in assessing damages for negligent misstatement, this causes incoherence in the law. Therefore, pro-fusionists argue that the same set of rules should apply for both common law and equity. After all, the aim of compensation is the same. It is to recover losses suffered by the claimant. Another area where the pro-fusionists argue that fusion should occur is when both common law and equity recognize different causes of action which give rise to the same remedy. For example, rescission. The common law recognizes fraudulent misrepresentation, fundamental mistakes, and duress as grounds to rescind a contract. But equity recognizes innocent misrepresentation, certain mistakes, and undue influence as grounds to set aside a contract. The end result of this is a degree of inconsistency. A claimant may be told that his contract is binding at common law, but voidable in equity. Take the case of mistake as to the quality of the subject matter as an example. The general rule is that if the mistake is not fundamental, the contract will be valid at common law. However, equity can render the contract voidable. This was what happened in Sow and Butcher, where the Court of Appeal set the contract aside in equity, even though it was valid at common law. Therefore, situations like this warrants fusion to ensure uniformity in the law. If fusion occurs, the effect of the Judicature Act is such that equity will prevail in case of conflict. Thus, it might have been expected that after the Judicature Act, the new court would exercise the power of equity to rescind the contract for mistake. However, despite the Judicature Act, there was reluctance by judges to recognize the full breadth of the equitable power to rescind for mistakes. The underlying reason for this reluctance was probably that the limits of the equitable power had not been clearly defined. Hence, fusion is not an easy task. In order to do so, the law on mistakes would have to be reformed entirely. Instead of looking at the different type of mistake which would allow a contract to be rescinded under common law or equity, the focus is on whether the mistake in question is serious enough to render a contract being rescinded. This would probably take a long time before fusion is set to occur in the future. Both the anti-fusion and the pro-fusion view are two extreme views. Certainly, it could not be said that the Judicature Act has only fused the administration and not the substantive law, but it also could not be said that complete fusion has taken place. Therefore, the straightforward answer as to how far the Judicature Act has fused common law and equity is that There's no complete fusion yet, but certainly there is some degree of overlapping between the laws. Hence, there is the middle ground approach where neither the anti-fusion view nor the pro-fusion view is favorable. This is the intermediate view, where it recognizes the distinction between legal rights and remedies and equitable rights and remedies, but at the same time, it also recognizes the evidence of fusion. For example, Lord Brown Wilkinson in Tinsley and Milligan was of the view that the rule is the same whether a plaintiff holds a legal or equitable title. He is entitled to recover if he is not forced to rely on illegality. In conclusion, the Judicature Act has fused the administration of common law and equity to allow them to be administered concurrently in a court under a uniform procedure. However, substantive-wise, it is submitted that the intermediate view should be endorsed, that common law and equity are working more closely together, they are coming closer but not yet fused. If complete fusion is set to happen in the future, perhaps what is needed is a statutory reform, as judges are forbidden to legislate. That would take a long time before it happens. Therefore, Lord Denning is of the view that the day has already come where the new equity is not to be found in legislation or judiciary, but in the spirit which is alive in our universities. That is the end of my presentation. Thank you.